involving a short-term rental that was denied due to the ordinance that requires that 2 units on one lot be owned by the same person in order to obtain a permit. In this particular property, there are 2 units on one lot that are owned by 2 different parties. So pursuant to the short-term rental ordinance, codes denied the permit application. That is what's being appealed today.
Okay, Councilman Davis, I know you had the marathon council meeting till 1 a.m., 6 hours plus. Welcome to the BZA, and we're happy to accommodate you. So tell us about why you're here.
Thank you, Chair, and I just want to thank the commissioners for volunteering their time, and I want to thank the code staff for always working the extra hours and the Metro legal staff. And this case, just like a lot of the cases, and you know my saying, what I do for the developer, I do for my regular citizen. Treat everybody fairly. And Tiffany lives in my neighborhood. She is my constituent. She owns this house. She lives there. And I know she lives there, not just because I'm her councilman, but I live in East Hill, which is that area. I live on Thomas Avenue, a couple blocks from her. Also, 2 of my fraternity brothers live on her street. Now, don't judge my organization because they accepted a ruffian from East Nashville like me. But, you know, Eddie Gray and his fiance live 2 houses down in the same unit. And also, my fraternity brother lives across the street with his grandmother that he's taking care of in the brick house. He works at First Tennessee Bank. And so I'm very familiar with the area, and it's right behind a cleaners that I know well in my district, and near the Smoothie King where my daughter works. So I know the area very well. And originally, you know, yeah, I know this has a common area, you know, but it wasn't really meant to hinder her ability to have an Airbnb permit. And the neighbors aren't against her having one. In fact, you know, if they didn't have work obligations, they would be here supporting her. And so with the neighbor support, you know, I wholeheartedly support her. If we can please grant her some mercy somehow, and even if you can't, you know how I feel. It's no hard feelings. You know, I still love y'all, but you know, if we can just help this hardworking young woman get her permit back, you know, I would greatly appreciate it. And if there's a way, there's no opposition from my end or the neighbors. And I know the school across the street, you know, has no issue. You know, it's an autism school, and with some of you know, I'm really big in supporting autism because, you know, my little brother has autism. And so they have no issues. They know her. They're not going to have a party house, you know. And the mechanic shop in front, you know, adjacent to her, and the cleaners aren't against it because the mechanic guy was like, I have a rowdier bunch here on Saturdays and on weekends fixing cars and listening to music while we're fixing the cars. You know, there's no opposition.
And I think that's all. I appreciate all that, and I think and I have no reason to doubt it, and it's, you know, accepted as fact and true. And I guess the only thing that I'm trying to figure out on these is, I mean, I know you said do it if you can, so that makes me ask, well, can I? And what I see is an item A appeal, which we, you know, we're saying the zoning, we would basically have to say, hey, the folks in our government that are interpreting the laws have done it this way, and we can either say, yep, that's correct, or nope, you were wrong. And it seems on this one with the two units on one lot that it's pretty clear. So I mean, is there a path that you see that this board could say that they were wrong?
And Councilman Davis, as you respond to Mr. Taylor's question, I'll also throw in that the reason that we are here today is because of a recent action from the Metro Council related. This is a new law, and so John Michael, the zoning administrator, will say, based on the law that was passed in Metro Council, that's why we're here, and that's our interpretation. So can you respond to that?
Well, you know, as we know, sometimes I don't agree with the laws that some of my colleagues pass. You know, good example, the sidewalk ordinance. Even though I respect their opinion, but you see me up here all the time. And how and I'm not trying to say I know better than you. This is how I look at it, how it was interpreted to me. And just this is why I come with up here with a sidewalk bill, is that, other council members were having certain issues. I was not having an issue. And what was told to me on record was, if you disagree with it, you could, and I'm not trying to continually put more work on the BZA, that if you go to the BZA, councilman, and, you can get it adjusted because, and it's unfortunately that she's being punished because a few council people were scared of party houses that I don't have the issues that they have, and she lives there.
But Councilman Davis, in all deference, it's not a few council persons, it's at least 21 council people that voted for this new law that prohibited this
But we
use.
also have, and myself was included with the sidewalk ordinance. I'll admit my guilt, okay? Voted thinking that we're going to get all these great new sidewalks, but we ended up, creating a headache for the BZA, because these are my words, not codes, okay? For creating a headache for codes, the BZA, Metro employees, and for neighbors, and for builders. And there were unintended consequences. And this is also that case. And we're revisiting this bill and others, so if there's a way, and I'm always sorry, David, to always come to you guys to fix issues when my constituents are in need. There was that one case, which I respected, we found another solution after we left here. But a lot of times people want us to have you exhausted all your resources. And I feel, and I could be wrong, and if I am, I apologize, but I feel with the stroke of a pen, you can end my constituents' pain, because my constituents are like my children. As a father, you want to end their pain. And I want to end their pain. And so I feel that Dr. Ewing and his associates can probably end her pain. And, and Alma, you're brilliant, and I feel that y'all can fix this. I mean.
Oh, the flattery.
But Alma still tells me no. I do something wrong, she gets on me.
Questions for Councilman Davis? Okay, thanks for being here. Do we have a further presentation, or are we going to hear from the applicants?
There is no further presentation. This doesn't have anything to do with prior operation. It's simply our interpretation of the law. Ordinance 2017-608 includes a provision that says property ownership of two family units cannot be divided. The two family units shall be owned by the same person, and one of the two units shall be the primary residence of the owner. So in this particular instance, as I said, there are two units on this one lot. The ownership is divided. Therefore, it does not meet the requirements of the code, and the permit was denied.
Okay. Please introduce yourself for the record, name, address, why you're here.
My name is Tiffany Gray. My address is 1032 Birchwood Avenue, Nashville, Tennessee, 37216. And I'm here because I was denied the short-term rental permit.
You applied for one, you didn't have one passed, you just applied for one and they told you because of this law?
Yes, and he said I could appeal it.
Okay.
In which I did and sent out all the letters. Before that, I also sent out certified letters to my neighbors, which I was instructed to do. I'm very close to them, and they had no opposition about it. And I had no idea, because my house is just a single-family home. I wasn't aware.
So this is an appeal process, and you're asking us to overturn the opinion of the zoning administrator. So I will ask you, why did he make a mistake in interpreting this recent law as it relates to you?
If I may.
Yes.
My name is Ben Jordan. I live at 1011 North 5th Street. I'm here as a neighbor of Tiffany, the appellant, and to provide some context for this conversation and this request for an appeal. Tiffany purchased this property in December of 2015. Shortly afterwards, in around March, she reached out to me because she knows that I'm in the line of work of helping people permit and those types of things. So She expressed at that point her interest in possibly pursuing a short-term rental because it was kind of new on the horizon, and she knew at some point she would want to pursue it. At that point, I went and looked at the location. I was familiar with the project where she purchased her home, and I was familiar with the builder and whatnot. And so, at a street view glance, it looked like it may be an SP or an HPR scenario. If it had been worst-case scenario, an HPR scenario, I advised her at that time that as long as there's only one permit for short-term rental, you should be okay. She had some job change and whatnot, and so she didn't pursue it immediately, but here in the last year, she's reached out to me about pursuing a permit. In December, she made that application, sent out the notifications, and was denied, and she, over the holidays, reached out to me again and asked me why would she be denied, and I was kind of thrown aback as well because through the course of watching or tracking her location and what was happening with it and looking at it a little bit closer, it turns out that the only reason is because of this new ordinance. And for the contextual understanding is that the timing of it, she just got caught in the lurch, not expediting her permit in a more timely manner, but she was allowed to make application for a property that they weren't going to permit anyway, but now she's in this appeal process. When she purchased it, it was an R6 lot. It's not an HPR. There's no homeowners association. The only thing that distinguishes this property is that it's got a common area that was designated by the builder. And for the sake of discovery, we want to be clear about why she's being held out of this privilege or this permitting privilege as a owner-occupied property. And then we just wanted to go through this course as a record just to make sure that she's exhausted all possibilities at this level.
So to restate the question, is there anything that you can provide us with that the zoning administrator made the incorrect decision to deny this permit?
Well, the legislation and the ordinances subsequent to her ownership. Her intent when she first purchased this was to eventually pursue a short-term rental. Up until recently, within the last 18 months, that has been put in question. Not to her fault, but it's just a legislative process that has caught her. And we're just making an appeal at this level just for her to be permitted.
Okay. Questions for the applicant?
I just want to clarify that you only own one of the 2 units located at 1032 Birchwood.
Yes, ma'am.
Okay, thank you.
Anything else to add?
No.
Okay, we're going to close the public hearing discussion.
Well, I mean, I think this is one of those situations where, you know, I personally have no issue at all with a homeowner having a short-term rental unit in their home. But in this case, the law just doesn't allow it. I mean, it's not whether I really think that they should have it or not. That opinion really is irrelevant. The question that we have is, you know, did the zoning administrator err? And based on, you know, the evidence that's presented, I don't think the zoning administrator did err. And what that leaves us with is kind of, in this case, a yes/no question. In other cases, we are able to have a remedy. But in this case, if the yes/no question is no, the zoning administrator did not err, then we really can't do anything. So, I mean, I think it's a little frustrating to be asked to solve a problem that we really don't have any authority to solve. And like I said, I feel bad about it, but I don't see a path to, based on the testimony, to do anything other than say the zoning administrator didn't err.
More discussion?
No, I agree with Mr. Taylor, and I think that our hands are tied no matter how deserving this appellant is. So I would move that we uphold the decision of the zoning administrator.
Okay, motion's been made. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. Good luck.